This is Member Senator Pan's SB 1189. Whenever you're ready.
Okay, thank you. Good morning, Chair and members. Along with my joint author, Senator Jackson, I present to you Senate Bill 1189, which I know is a suspense file candidate. SB 1189 builds public confidence and ensures accurate autopsy reports by giving trained medical examiners more control over the autopsy suite and clearly defining who is allowed to conduct autopsies. We've been closely working with the opposition to address their concerns. If the bill makes it off the suspense file, we're committed to reducing the fiscal impacts laid out in the analysis while upholding the integrity of what happens in the autopsy suite. SB 1189 is important to clarify and codify the best practices taking place in an autopsy room to guarantee an objective and trustworthy autopsy system. We hope to continue working with the committee and continuing positive conversations with stakeholders to remove SB 1189 from suspense. Thank you.
Thank you. Senator Jackson.
Thank you. I'm not sure I can talk that fast, but I'll do my best. I am pleased to join Senator Pan in this process. This bill emanated out of a concern, at least for me, of something that happened in my district, a series of incidents that led to the dismissal of Ventura County Medical Examiner, where it was found that forensic autopsies were being conducted by unlicensed and unsupervised staff, indeed, in some cases, while the county medical examiner was on vacation in Florida. Ventura, California, Florida are a little far away, but that's where these autopsies were being performed while he was on vacation. And in response to these findings, it became readily apparent legislative action was required in order to ensure the public's faith in how these autopsies were being performed. And when you think about autopsies, for many family members, this is the loss of a loved one. Either they had no expectation, they need to know, they want to know why in order to get closure. It's a critically important both emotional and forensic issue, particularly if there is some level of improper behavior, homicide, or some kind of activity involved. And in regards to the fiscal concerns and those raised by the California State Sheriff's Association and the California State Coroners Association, we are working diligently and collaboratively with them and other invested stakeholders, working with Dr. Pan, who's got that critical science knowledge, as well as the need to try to, again, reaffirm the public's faith and confidence in this process. We recognize, though, that this is going to suspense. It is a work in progress, but we strongly believe it's a necessary element to be taking to shore up the confidence of the public in this process and to make sure that these autopsies are performed accurately, scientifically, so that both the public and law enforcement have the tools necessary to proceed accordingly. With that, we would appreciate your support.
Thank you, Senator Jackson. It's a lovely necklace, by the way.
Thank you.
Witnesses in support.
Douglas Chiappetta on behalf of the Union of American Physicians and Dentists with AFSCME. We want to thank Senator Pan and Senator Jackson for sponsoring this bill. We are supportive, obviously, we are co-sponsors. The bill seeks to protect the integrity of the autopsy process, and we couldn't ask for better authors. So we're going forward, working with the opponents and the proponents, and we hope for suitable language. Thank you, and support.
Jennifer Simoes with the Medical Board of California. We support this bill for policy reasons. Thank you.
Joshua Golka with the American Federation of State, County, and Municipal Employees in support.
Sean Hoffman with the California District Attorneys Association. We're supportive in concept, hope to see the bill move out of committee so we can continue to work with the authors on a few lingering concerns.
Witnesses in opposition, please come forward.
Good morning, Mr. Chair and members. Danielle Sanchez on behalf of the California State Coroners Association, respectfully in opposition today. I do want to say we appreciate the very productive discussions we've had with both senators on this, and we look forward to continuing that as it goes to suspense. I would note that the bill as currently drafted represents a significant overhaul from the existing coroner medical examiner kind of structure within California. And really the crux of the issue for us is the combination of manner and cause as the bill is currently drafted. While cause is really the medical determination, manner includes many more things based on the investigation done by the coroner's office, law enforcement, and a host of other things. And so for us, it's very key and important that the cause and manner be looked at separately. and handled differently. We recognize the desire for there to be language to codify the role of the physician in determining cause as the medical determination, but we look forward to conversations about how we look at those two, cause and manner, separately going forward. Based on the bill as it's currently drafted, there is likely to be fiscal impacts in the hundreds of thousands to contract with a single licensed physician to handle the additional manner determinations, and so extrapolated that over the state and the number of physicians that would be needed to now handle both duties. It would be quite a significant fiscal impact on coroners. So we look forward to conversations, and for those reasons, we respectfully oppose today.
Mr. Chair and members, good morning. Corey Salzillo here on behalf of the California State Sheriff's Association. I would echo Ms. Sanchez's remarks, particularly regarding the author's willingness to work with us on problems that we have identified with the bill. I would raise the same concerns, policy and fiscal, that Ms. Sanchez listed, and I would also note, in addition, that there are other tasks in connection with an autopsy and postmortem examination that are done that don't necessarily need to be done by doctors, and so I hope that the amendments, as we work them out, will address the appropriate roles of people involved in autopsies. I would also note a policy concern that the bill precludes law enforcement from being in the room during an autopsy suite, and so we'll address those, hopefully as well, through the language, but remain in opposition. Thank you.
Thank you. Any additional witnesses in opposition? Finance.
No file.
Comments or questions from committee? Seeing none, would you all like to close?
I just wanted to say that I appreciate the conversations we're having with both the coroners and the sheriffs, and we look forward to actually settling many different issues that were brought up today, and hope that that will be taken consideration by this committee and allowing this bill to move forward so we can complete those conversations. Thank you.
Thank you. Thank you. Without objection, we move this item to the suspense file. Moving right along with Senator Galgiani's items on the agenda, SB 1419 by Senator Galgiani members. Witnesses in support. Witnesses in opposition. Finance.
No file.
Comments or questions from committee? Seeing none, without objection, we move this item to suspense file. Moving on to SB 1456. Witnesses in support. Witnesses in opposition. Finance.
No file.
Comments or questions from committee? Without objection, we move this item to suspense file. Moving on to Senator Mendoza's item, SB 1472. Witnesses in support. Witnesses in opposition.
Ed Behrens on behalf of the Los Angeles County Board of Supervisors in opposition.
Thank you. Mr. Answer, you're welcome.
Mr. Chairman and members, Andrew Antwi here on behalf of the Los Angeles County Metropolitan Transportation Authority. We're in opposition to this bill. I might add that the Los Angeles City Council has recently voted to oppose the bill. A letter will be forthcoming reflecting that. There's several council members in town today. There's a long list of opposition. And to the fiscal, Mr. Chairman, I just note that right now the county is proposing a $120 billion tax to provide revenues for transportation. We just saw the Expedition Light Rail line just open in Los Angeles County. This measure, as it is proposed, would potentially jeopardize the ability of the voters of the county to convince 2/3 of the voters of Los Angeles County to bring more revenue to transportation. So we're very concerned about the impact of this measure. Fomenting a board governance fight in the same year that you're trying to convince voters to approve a tax by 2/3 is not a recipe for success. And if we get to the point where the measure fails, then there will be no resources to fight over, and projects won't be there at all. So with that, we oppose the bill.
Thank you. Comments or questions from committee? Seeing none, without objection, we move this item to the suspense file. Senator Mitchell, welcome.
Thank you, sir. Good morning, everybody.
Senator Mitchell, you have 3 items before us. All candidates for suspense. We'll begin with SB 941.
Thank you very much, Mr. Chair. Good morning, colleagues.
Good morning.
Under current law, counties may assess fees against parents or guardians of youth who are involved in the juvenile justice system. Parents and guardians are charged fees for each night their child spends in juvenile hall or other detention facilities, each day their child is on electronic monitoring, each drug test their child must submit to, probation supervision for their child, pretrial investigation of their child's case, and court-appointed counsel, ranging from hundreds of dollars per child in some counties to thousands of dollars in others. These fees place a heavy financial burden on some of the state's most vulnerable families. SB 941 would stop the assessment and collection of admin fees charged to families when their child is in youth detention or on probation. By doing so, it would relieve families of both the economic and familial strain caused by current practices and foster the rebuilding of families rather than breaking them financially. According to the committee analysis, SB 941 will cause minimal loss in revenue to counties, as counties already see very little gain financially from these assessment and collection practices. This is because families who are charged with fees often cannot afford to pay, and counties see such impact in their often low collection rates. In fact, these fees often make up less than 1% of funding sources for probation and public defender departments. Our juvenile system is meant to promote rehabilitation and strengthen family stability. I appreciate that the committee analysis reflects this, noting that removing the existing fee scheme will likely reduce fiscal costs associated with CalWORK's family stabilization services, and would note that it would also reduce out-year costs associated with youth reentry into the juvenile justice system due to family instability caused by the fees. Today, we have several witnesses to speak in support of the bill from the UC Berkeley Law School Policy Advocacy Clinic, and I ask for your favorable consideration.
Thank you. Witnesses in support.
Good morning. My name is Alex Kaplan. I'm a law student in the Policy Advocacy Clinic at Berkeley Law, where we've been researching juvenile fees for over 2 years. We surveyed the 58 chief probation officers about county practices and then submitted over half a dozen detailed Public Record Act requests across the state to better understand their assessment and collection practices. The bill analysis estimates that over between $5 to $10 million would be lost in potential revenue each year statewide for the inability to assess juvenile fees. We believe the actual number is on the smaller end of this range because most counties are spending nearly as much trying to assess and collect these fees as they're actually able to collect. And we think that's largely because they're trying to collect fees from low-income families who can't afford to pay. As the analysis also suggests, the net costs associated with the collection of outstanding debt are harder to ascertain, as many counties do not regularly track the amount of outstanding debt over time or overall. But we believe that, for the same reason regarding the income level of families, the amount of debt, of old debt counties would actually be able to recover is far lower than what they might say is outstanding. Moreover, these fees account for a very small proportion of the funding sources for county probation and public defender departments. For example, in fiscal year 2014-15, Sacramento County assessed roughly $3 million in juvenile fees, but only collected a net $181,000, especially where the county's probation budget was $142 million that year. Further, counties that have stopped charging juvenile fees have done so without high negative impact on their provision of services or the budget. For example, when Los Angeles County imposed a moratorium on such fees, it removed $2.7 million from the county's then $700 million probation budget, but did not require the department to discontinue any services or lay off any staff. In fact, Alameda County placed a moratorium on the assessment of fees and collection of fees in this March after comparing the high pain that such debt causes to families and the low gain, less than $170,000 annually, that they were seeing on the books. The state legislature itself made a significant step in the right direction last year by enacting SB 504, authored by Senator Lara, which eliminated the fee for juvenile record sealing across the state. We hope the state will expand upon the success of SB 504 by enacting SB 941 to eliminate all juvenile fees and free families from the debt associated with these fees, debt that brings much pain to low-income families, yet very low gain to the state. Thank you.
Thank you. Additional witnesses in support.
Good morning. My name is Stephanie Campos-Buoy, and I'm a supervising attorney in the Policy Advocacy Clinic at Berkeley Law. I'm going to briefly discuss how SB 941 would result in savings to both county departments and our communities. By repealing county authority to assess and collect juvenile fees, SB 941 would eliminate the need for financial evaluation officers and judges to assess and order these fees, as well as for collections officers and the Franchise Tax Board to seek payment on outstanding debt. Counties are expending significant time and resources toward juvenile fees alone. For example, this last fiscal year, Humboldt County spent over $206,000 in pursuit of just $232,000 in fees. Additionally, as the analysis notes, SB 941 would result in some immeasurable but significant savings for families across the state. Many youth involved in the juvenile justice system come from families living in poverty. Billing families for fees only exacerbates these existing levels of poverty and cause families to limit spending on positive goods like education and healthcare, and ultimately can push families to partake in suboptimal long-term decisions, all of which can have costly ramifications. By pushing families deeper and deeper into poverty, fees also increase the chance that youth will become involved or re-involved with the juvenile justice system. In fact, fees themselves can have a criminogenic effect. That is, increase the chance that an individual will recidivate in order to repay the county. With a higher chance of recidivism, the costs associated with crime will also increase and accumulate to the county, like the cost of detention and supervision for those who commit crimes, as well as the costs associated with property and medical expenses for those who experience crime. Further, a study of juvenile fees in Alameda County by a group of public policy students found that the eliminations of fees would generate about $192,000 in net benefits to society annually and over $5 million in net benefits to society over time. And that's just in Alameda County alone. Benefits on a statewide level could easily reach hundreds of thousands of dollars. SB 941 would result in positive change for the more than 100,000 youth in California who are referred to probation every year and that face the assessment of these fees, and the hundreds of thousands of families across the state with outstanding debt from past involvement with the juvenile justice system. Thank you.
Thank you. Additional witnesses in support.
Thank you, Mr. Chair and members. Jessica Bartholow with the Western Center on Law and Poverty. We're a sponsor along with the Lawyers Committee on Civil Rights, the East Bay Community Law Center, and Youth Justice Coalition. Thank you.
Thank you. Witnesses in opposition. Finance.
No file.
Comments or questions from committee? Seeing none, Senator Mitchell, would you like to close?
I ask for your favorable consideration.
Thank you. Without objection, we move this item to the suspense file. Moving on to your SB 1201.
Thank you, sir. SB 1201 is a bill that will expand availability of placements while also reducing delays in relative placements for children in foster care. This bill will address needless impediments to appropriate relative and foster care placements by conforming state law to federal requirements regarding caregiver criminal history reviews. Specifically, it will eliminate the complex exemption process and will align the list of non-exemptable crimes with those required under federal law. California's current laws relating to the criminal history of a prospective foster or kinship caregiver are overly broad and unduly restrictive. Several lists of crimes have been deemed non-exemptable. For all other crimes in which any household member has been convicted, no matter how minor, how long ago, or how unrelated to child safety, an exemption must be granted to approve the home for placement. These changes do not compromise child safety. California law will continue to prohibit, without any discretion to make exemptions, placement with any person with a serious or violent felony conviction, or with an assault, battery, or drug-related felony conviction within the last 5 years. Furthermore, the 2015 enactment of AB 403 requires statewide implementation of the resource family approval process. Under RFA, all foster and relative homes will be required to undergo a psychosocial assessment, which will involve several face-to-face interviews and a thorough consideration of any criminal history of the caregiver or household members. Currently, there are more than 5,800 kids living in group homes in California. And under the continuum of care reform effort, it's our plan to phase out group homes by January 1st of 2019. So clearly, we must do all that we can to expand recruitment efforts and the pool of qualified foster care homes to accommodate this population. We have a witness here to speak in support. I ask for your consideration.
Witnesses in support.
Good morning. Honorable members, my name is Yolanda Pineda, and I'm an attorney at the Children's Law Center of California. Oh, thank you. We represent children in dependency court systems in Sacramento, Los Angeles, and Placer counties, approximately 33,000 children in foster care. I want to start by thanking Senator Mitchell for authoring this important legislation. SB 1201 would help address the issues by implementing a meaningful process to evaluate a safe placement for children without some of the unnecessary hurdles that exist today. I believe the following three common case scenarios best demonstrate the profound benefits of this bill. First, far too often, our clients are placed in the homes of strangers or in congregate care because a relative or family friend who is available for placement has a petty theft conviction from 20 years ago, or similarly, a non-child safety-related conviction. I can't tell you how many times I've had a grandparent plead with me that they are no longer the person who committed a petty crime decades ago, long before they even had children. They're devastated to hear that a child that they love has to stay in foster care during this bureaucratic and lengthy exemption process. Second, potential caregivers are often excluded from even being considered for placement because of a conviction that the county agency mistakenly believes is non-exemptable because the current law is extremely confusing. It has both a long list of non-exemptable crimes and a cross-reference to the penal code sections that include 2 other long lists of crimes. By conforming state law to federal requirements regarding exemptable versus non-exemptable crimes, SB 1201 would simplify and streamline the list of non-exemptable crimes. Importantly, all violent felonies and felony crimes against children would still be non-exemptable, as would assault and drug-related felonies within the past 5 years. A background check and thorough review of any criminal history, even misdemeanor crimes many years ago, would still be required for all prospective placements. SB 1201 would remove a few crimes from the non-exemptable category because they are either nonviolent felonies or misdemeanors. These crimes are more appropriately considered on a case-by-case basis rather than a categorical precluding placement. The third case scenario we repeatedly encounter is an undue delay in placement because of the exemption process. I had a case transfer from Los Angeles County where the grandparents struggled for a year to be approved for placement. They had to appeal to the highest levels of the agency in order to be granted placement. The grandparents were so appropriate that the department eventually recommended the child be adopted by these grandparents. As a final comment, it's important to emphasize that SB 1201 will not compromise child safety. Rather, they present a sensible approach to the assessment of a prospective caregiver's ability to safely provide a home for children in light of his or her criminal history. We urge you to support this significant legislation.
Thank you. Additional witnesses in support. Witnesses in opposition. Finance.
No file.
Comments or questions from committee? Senator Bell.
Just getting the foster family program going is very difficult. I've been working on that for 20 years, and it's very hard. And one of the things people should know is that the group home rates compared to foster family rates, you want to talk about a huge differential. If you want to talk about fiscal impact, you got to look about how much money it costs to put somebody in a group home versus foster family home. It's thousands of dollars per month difference. And I think it's very important that we support foster families. And the one thing I like about the bill is the added checking of the foster family. I think that's good policy. I think we need to do more of that to avoid any problems. So I wanted to say that foster families is a bargain from a fiscal standpoint.
Thank you. Additional comments or questions? Seeing none, Senator Mitchell, would you like to close?
Just very briefly, sir, in closing, the analysis suggests that there would be significant additional costs because this bill would expand the exemption process. Our assertion is that current law requires that all crimes other than minor traffic violations go through the exemption process, so that process already exists. We don't think we'd be adding to the workload. Secondly, the psychosocial assessment that Senator Bell talked about covers all aspects of an applicant's background, including any criminal history. And so again, we don't think that we would be adding to the workload of the RFA process that will be coming online in coming months as the kind of new culture shift happens in foster care. Lastly, I would just add, in talking about this bill across the state, I learned about the case of a mayor of a large city in California who is a foster parent, whose own foster care license was held up because of a civil disobedience arrest decades ago. And so I thought that was a classic example of a case where that should not have impeded their ability to foster in a time when, for example, in LA County, we have 1/3 the needed foster family homes that the foster care population is bringing to bear. And so I ask for your favorable consideration.
Thank you. Without objection, we move this item to the suspense file. Moving on to your SB 1466.
Thank you, sir. This is continuing to deal with the foster youth population. And this bill is a bill designed to ensure that foster youth are appropriately screened and treated for trauma. This bill recognizes that children who've been both abused or neglected, as well as removed from their home, have, by definition, experienced trauma in order to ensure their timely treatment. The fact that they're in the child welfare services system itself suggests that they've experienced and witnessed repeated traumas throughout their lives. California has a complicated delivery method of mental health services for foster youth, with mild to moderate cases handled by the health plans and moderate to severe cases handled at the county level. This bifurcation has led to reports of delay in services for some, our most traumatized and vulnerable children. The purpose of this bill is to identify and treat trauma early, because research tells us conclusively that unidentified trauma ultimately results in much higher cost to society as well as the affected individuals. As we've talked about, the kids in foster care are already experiencing such disruption in their lives. We don't want them caught in between a tennis match regarding who is responsible for providing services, health plans, or the counties. There are some ongoing issues identified by your analysis that we would like to continue to work with staff on, issues involving really trying to identify the extent to which the costs identified in the bill are actually offset by savings. And secondly, the question of what level of government is ultimately responsible for the early detection and intervention with regard to trauma. As you all will recall, in 2011, the state realigned to counties 100% of the responsibility for the EPSDT program, it's Early and Periodic Screening and Treatment Program. When realignment was presented to the legislature by the administration, we were assured that counties would have sufficient resources to administer this program, which is an entitlement for all children in Medi-Cal. As the committee analysis suggests, my bill would incur costs because more children who are entitled to services would actually get them. Based on the realignment program, counties are responsible for all services that our children are entitled to under EPSDT. However, if the state has we believe the state has a much bigger problem. If we are sanctioning an EPSDT system where we know entitled children are going without services, that's in direct violation of federal law. Therein lies the challenge. Finally, Mr. Chair, I'd remind us all that, again, the E in EPSDT does indeed stand for early, and federal law requires early screening. It's the law. So I hope we can work together in your staff to ensure that we are indeed providing early detection and screening to this very, very vulnerable population. With me today are Mr. Mecca from the Welfare Directors Association and Mr. Bowders from the Californians for Safety and Justice Organization to speak in support.
Thank you. Witnesses in support.
Thank you, John Bowders from Californians for Safety and Justice. The Senator really said it all very well. Just to add a couple things. We're proud to co-sponsor this bill with the Youth Law Center and the California Youth Connection. A public safety organization is here on this bill simply because we're seeing an increased number of young people entering the juvenile delinquency system. Many of those kids come in and they are victims of abuse and neglect. When they do not get early interventions and treatment when they become 18 and age out, they then become offenders and criminals to us, and we forget that they were once victims. It's very important for us to ensure that a high specialty level of services reaches victims of trauma early in life. Early, as the Senator noted, is the first word in EPSDT. We believe this bill is not an expansion of an existing entitlement. It simply makes sure that children who need the service get it early to prevent larger social and economic costs later. Thank you.
Thank you.
Thank you, Mr. Chair. Frank Mecca, Executive Director of the County Welfare Directors Association. My members administer the foster care system on your behalf, and we see the effects of untreated trauma every day. We're fully in support of the measure to help children get identified and treated early so that we don't see the more expensive manifestations, both on a human level and to society and to public systems, that results when children aren't screened early. We have a system where children are entitled to mild to moderate services by health plans, moderate to severe services by county mental health plans. Children are entitled to those services. We think this bill actually makes the system work better so that children who are already entitled to those services can get them, and we can all see savings in the long run.
Thank you. Additional witnesses in support. Witnesses in opposition. Finance.
No file.
Comments or questions from committee? Seeing none, Senator Mitchell, would you like to close?
Just in closing, Mr. Chair, I would say that I think historically in the foster care system, our assumption was if we simply remove the child from the environment in which they experience trauma, then that was enough, that we put them in a safe, stable environment, and that would change the course of their lives. We have found through the years, and hundreds of thousands of California youth who've been touched by child welfare services, that removing them from the environment simply is not enough. As I said earlier, clearly they experienced some form of trauma, which is why they were removed from their home, and we believe that they deserve not only to be in a safe environment, but to receive the appropriate and timely and early treatment to truly change the trajectory of their future. So with that, I ask for your favorable consideration.
Thank you, Senator Mitchell. Without objection, we move this item to the suspense file. Members, that brings us to the end of our agenda. We're going to open those items that are still pending to allow members to add on. We're going to begin with SB 1186. That is a due pass recommendation. Secretary, please call the absent members.
Bell? Bell, aye. Mendoza? Aye. Mendoza, aye. Nielsen? Nielsen, aye.
7-0, that item is out. Moving on to Senator Wolk's item, SB 1318. That is a due pass recommendation. Secretary, please call the absent members.
Bell? Bell, aye. Mendoza?
Senator Wolk at 1318. 4-2, that item is out. Moving on to Senator De Leon's item, SB 1393. This is a due pass recommendation. Secretary, please call the absent members.
Bell? Bell, aye. Mendoza? Aye. Mendoza, aye. Nielsen? Nielsen, no.
6-1, this item is out. Members, this concludes our appropriations meeting for today. Thank you.